All right, while most people were asleep last night, something dropped into a federal court record that fundamentally shifts the terrain of one of the most consequential legal battles unfolding in American institutional history right now. And I'm going to tell you exactly what it is, why it matters, and why virtually every mainstream outlet covering it this morning is describing the wrong thing. Because here's what's happening in the coverage. Anchors are treating last night's development as a chapter in the Pam Bondi story. They're framing it as a continuation, as the next paragraph in a narrative that already had a protagonist and a trajectory. But that framing misses the entire point of what was filed at 11:47 p.m. What was filed last night isn't a new chapter in the Bondi story. It's the opening of a different story entirely, one that reaches past the Attorney General's office and lands somewhere much closer to the top of the executive branch. I've been in these documents since before sunrise, and I'm going to walk you through exactly what happened, why the timing matters, why the specific legal mechanism being used is significant, and why the administration's pre-dawn response, 22 pages filed at 4:31 in the morning, tells you almost as much as the filing it was responding to. But first, let's build the foundation. Because if you don't understand what was already in place before last night, the overnight development looks like a procedural footnote. It isn't. It's a detonation. And detonations only make sense when you understand what was already under pressure. Pam Bondi did not walk into the Attorney General position under ordinary circumstances. The expectation surrounding her appointment wasn't the traditional profile of a law enforcement steward, someone tasked with running an independent institution according to the internal logic of that institution. The public record from her confirmation hearings, from the early policy directives that moved through the DOJ in her first weeks, from the restructuring decisions that reshaped the department's posture in the initial months, all of it pointed to a different kind of role. She was positioned to function as a translation layer. Political priorities on one side, litigation posture on the other, and her job to convert one into the other with fidelity and without friction. That's not an editorial characterization. That's the documented reality visible in how the appointment was framed, how the early tenure unfolded, and how the DOJ's operational direction shifted in measurable ways almost immediately after she took the position. What nobody inside that strategy appears to have fully accounted for was the specific vulnerability that comes with building legal architecture on loyalty instead of legal merit. Loyalty is an efficient construction material when everything goes according to plan. It becomes catastrophically fragile the moment a federal judge enters the picture who has been quietly reading everything, including the internal communications that were written with the assumption that they would never leave the room they were created in. That judge exists in this proceeding. He read those communications, and what he found in them became the foundation for a ruling that used a word about the United States Department of Justice that, in the context of a federal court order, functions less like a descriptor and more like a verdict. That word was predetermined. Let me give you the timeline, because the architecture of how this developed matters for understanding why last night happened when it did and why it hit as hard as it did. 14 months ago, a pattern began taking shape across a range of DOJ enforcement decisions. State attorneys general, a coalition of them, started noticing something that didn't fit the internal logic of the cases they were watching. Any single decision, examined on its own, could be rationalized. The legal reasoning was present. It might have felt constructed rather than discovered, but it existed on paper. The problem wasn't any individual case. The problem was the pattern across all of them. When legal judgment is genuinely being applied case by case, the facts drive the outcomes, and facts vary. Cases that look similar on the surface often diverge substantially when you get into the details, and those divergences should produce different outcomes at least some of the time. What the coalition was watching didn't behave that way. The outcomes were consistent in a way that the factual variations between cases simply couldn't explain. Too directional, too uniform, too resistant to the kind of deviation that genuine case-by-case analysis naturally produces. When outcomes don't change even as the facts change substantially, you're not looking at legal judgment being exercised. You're looking at something that was decided before the legal analysis began. 11 weeks ago, the coalition formalized that observation into coordinated legal action. 984 pages. 23 separately documented decisions, a theoretical framework built around the argument that the consistency across those decisions wasn't coincidental, it was structural. That someone operating above the case level had set the direction, and every case level decision was being shaped to arrive at conclusions that had already been selected. 7 weeks ago, the presiding judge ordered a sealed evidentiary development period. 30 days. Both sides submitting documentation that the public couldn't see. The docket went quiet. In that particular way, federal dockets go quiet, when the real work is happening in sealed submissions rather than public filings. Administrative entries, scheduling notes. Nothing that told the outside world what the judge was actually sitting with. What he was sitting with turned out to be the internal communications of senior DOJ leadership. The kind of communications people write when they believe no one outside a small circle will ever read them. The kind that reflect what people actually think rather than what they want attributed to them on the record. Direct, specific, written without the caution that comes from knowing you're being watched. The judge was watching. 4 weeks ago, a supplemental brief arrived in the record. 41 pages total, 30 of them sealed. When 73% of a court filing is sealed from public view, the content is not procedural housekeeping. Courts don't seal administrative arguments. They seal things that require protection from immediate public disclosure because of their nature and significance. The ratio was communicating something before anyone read a word. 2 weeks ago, a closed emergency hearing. 4 hours and 14 minutes. No public entry. Emergency hearings that run over 4 hours aren't happening because someone wants to argue scheduling timelines. They happen when what a court has found is serious enough to require an extended substantive conversation about where the entire proceeding goes next. Then last Friday, the ruling. The one that found predetermined orientation in DOJ litigation decisions. The one that imposed 18 months of structural oversight on the department's decision-making in the affected categories. The one that put the word predetermined in a federal court order about one of the most powerful law enforcement institutions in the world. That ruling, on its own, was seismic. What happened last night turned it into something larger. Here is exactly what the overnight filing contains. And I want to be methodical about this because the coverage this morning is treating it as an addendum to the Bondi narrative. And it isn't. The state coalition filed a supplemental motion. 37 pages. Timestamped at 11:47 p.m. You do not file at 11:47 p.m. unless you are racing a deadline. The Wednesday compliance conference was the clock they were running against, and they needed this document in the record before that proceeding opened. Someone was working through the night to get it there. That level of urgency isn't theatrical. It's operational. What the motion does, and this is the critical thing the morning coverage is missing, is shift the target of the inquiry, not the subject matter, the origin point. The court's existing finding, the predetermined orientation ruling from Friday, was built on internal DOJ communications. Senior leadership talking to each other about how to approach enforcement decisions in the affected categories. The court documented a pattern in those communications that supported the finding of predetermined outcomes. That was the evidentiary foundation of the ruling. The coalition's overnight motion argues that those internal DOJ communications were not the source of the predetermined orientation. They were the delivery mechanism. The argument is that the direction didn't originate inside the department. It arrived there. It was transmitted from outside, specifically from the White House policy coordination apparatus. And what the court documented inside DOJ leadership communications was the evidence of that direction being received and implemented, not created. Read that again, because it changes everything about what proceeding this is. If the coalition's argument is correct, then the internal DOJ communications the court already reviewed are not the story. They're the echo. The original sound came from somewhere else, and the court, under the structural injunction framework it already established, is now being asked to consider whether understanding the origin of the predetermined orientation is necessary for the compliance framework it's demanding to actually address the problem at its source. The metaphor the coalition is essentially deploying is this: you found contamination in the pipes. You've ordered a cleanup of the pipes. But if the source of the contamination is in the reservoir the pipes connect to, cleaning the pipes doesn't solve the contamination problem. It delays it. And the oversight framework you've established becomes insufficient by design because it's aimed at the wrong point in the system. That is a legally coherent argument. Whether it succeeds is a different question, but its coherence is why last night matters. Now let's talk about the Trump dimension, because this is where the overnight filing stops being a legal procedural story and becomes something qualitatively different. The White House policy coordination apparatus referenced in the coalition's motion is not abstract. It has personnel. It has a documented operational history. During the 14-month window the court has already determined is legally significant. That apparatus was actively and visibly engaged with the Department of Justice on precisely the categories of enforcement decisions the structural injunction now covers. That engagement is not a matter of sealed submissions or classified information. It's in the public record. White House visitor logs reference the policy coordination meetings. Joint public appearances between the Attorney General and senior White House officials on enforcement priorities are documented. The public-facing coordination between the Executive Office and the DOJ during that period is a factual baseline that the coalition is using as the scaffolding for its argument about what the sealed communications will show if the evidentiary record is extended. The coalition is not alleging that Donald Trump personally reached into specific litigation files and directed individual case outcomes. That would require a different kind of claim and a different evidentiary foundation. What the filing argues is something narrower in legal terms and in political terms more durable. It argues that the policy framework within which all those predetermined outcomes were operating, the framework the court already found, was not a Bondi creation. It was a system operating under direction. And the direction came from coordination that originated above her. In legal proceedings, there is an enormous difference between the person who designs a system and the person who administers it. The designer has a different kind of exposure than the administrator. The coalition, by arguing that Bondi's DOJ was implementing rather than originating, is pointing the court's attention toward the design level of the system that produced the outcomes the court has already condemned. The word Trump does not appear in the operative language of the overnight filing in the way cable news would typically require to say his name is in a court document. But the structural logic of the argument places a specific category of person, someone operating above the Attorney General in the executive hierarchy, engaged in policy coordination with her during the relevant period, within the apparatus the filing specifically identifies at the center of. The inquiry the coalition is asking the court to open. That person has a name. The court knows how to read a legal filing, and this judge has already demonstrated that he reads everything placed before him with considerable precision. The administration's response arrived at 4:31 in the morning, 22 pages. That pace is significant. You don't produce 22 pages of organized legal argument in the hours between 11:47 p.m. and 4:31 a.m. unless the document was substantially prepared before the filing it's responding to ever landed, which means the administration had advance intelligence that this motion was coming. They knew. They prepared for it. And they filed the moment the clock was late enough to justify a response. What the 22 pages argue breaks down into three components with very different levels of legal credibility. The first argument is jurisdictional, that the coalition's motion exceeds the reach of the court's structural injunction framework and should be rejected before it's ever considered on its merits. This argument has genuine legal weight. Whether a structural injunction directed at a federal department can extend its evidentiary reach into White House communications is not a settled question. The administration is pointing at real constitutional architecture here, and the court may well agree with them. The second argument is executive privilege. Presidential communications with senior advisors in the exercise of executive functions carry among the strongest protections available in American law. The Supreme Court has affirmed this repeatedly. The government is not wrong to raise it. The question, and this is where it gets complicated, is whether asserting the privilege prevents the inquiry entirely or simply governs how the inquiry proceeds and what the compliance framework is required to address. The third argument is the weakest of the three, and the ratio of the brief reflects this in an interesting way. 20 pages of jurisdiction, privilege, and compliance theory. 2 paragraphs directly engaging the substance of what the court actually found. The predetermined orientation, the documented pattern, the factual foundation of the ruling itself. 2 paragraphs. In a 22-page emergency response to a filing that directly challenges the adequacy of the compliance framework being built around that finding. When a legal brief spends 90% of its length arguing procedural and constitutional walls, and 2 paragraphs engaging the underlying facts, it tells you something about confidence. Specifically, it tells you where the confidence lives and where it doesn't. The walls are real. The walls are being argued by skilled attorneys with legitimate legal foundations, but the walls are being argued because engaging the substance on its merits is not where the administration believes it can win. That ratio, consistently, is the tell. Let me tell you what's happening in the spaces where this is being processed seriously, not in television studios, but in the offices and chambers, where the people who built and defended institutional legal architecture spend their working hours. A former federal appellate judge, 12 years on the bench, someone who has maintained public silence on this proceeding through every prior development, issued a 1-paragraph statement this morning. He described the jurisdictional question as genuinely close, not a frivolous challenge by the coalition, not an easy win for the government either, but a legitimately unsettled question that a reasonable court could resolve in either direction. He called the privilege argument strong but not absolute. And then he said something that landed heavily in the rooms where people were reading it. In 18 years of observing federal litigation, he had never seen a structural injunction proceeding expand in scope this rapidly, this close to a compliance deadline. He did not characterize that as good or bad. He characterized it as outside the range of his experience. That characterization from someone with his frame of reference is not a casual observation. A constitutional law professor who's published work on executive privilege and separation of powers is cited in appellate proceedings across multiple circuits, spent the early morning analyzing the overnight filing publicly. His assessment of the coalition's legal theory was that it was coherent. Not guaranteed, but coherent, while facing what he described as a jurisdictional wall of genuine height. His prediction was that the court is unlikely to pierce executive privilege in the first instance, but may use the compliance framework requirement to compel the government to represent on the record what the full decisional chain looked like. And that representation, made to a federal court under the professional obligations that bind attorneys in federal proceedings, is itself evidentiary in nature. You don't get to describe the decisional chain to a court and then later contest what you described. A former senior career attorney inside the DOJ, 26 years in the institution, who departed in the past year under circumstances that themselves generated significant internal attention. This person spoke to a reporter this morning, off the record. The substance, shared without attribution. The overnight filing changes the posture of this proceeding in ways the DOJ's compliance team was not prepared for as of yesterday evening. The compliance framework being developed operated on the assumption that the evidentiary inquiry stayed inside the department. That assumption, as of 11:47 p.m., is no longer reliable. The team building the compliance response is now building it on a foundation that shifted under them overnight. Here is what the landscape looks like right now in concrete terms. The compliance conference happens Wednesday. It now proceeds under the shadow of a pending motion that directly challenges whether the compliance framework being presented can be considered adequate at all, without accounting for the full decisional chain the coalition is pointing toward. The conference can't ignore the motion. The court will have to address it, at minimum procedurally, before the compliance discussion can proceed on its original terms. The 60-day compliance deadline is running. The team responsible for building that compliance response is doing so while the definition of what adequate compliance requires is actively being litigated above them. The Circuit Court is considering a stay petition in a parallel proceeding. That court is now doing so with an overnight supplemental filing in the district court that materially changes the factual and legal posture of what the stay petition is even about. The 9-month review hearing already has a calendar date. The 18-month oversight clock is running on every affected decision from the moment the structural injunction was issued. And the scope of what that injunction covers just became a live question again, because the coalition is arguing the injunction's compliance standard has to reach the source of the problem, not just the location where the problem was documented. The administration has real legal arguments available. The jurisdictional challenge is genuine. The privilege protection is among the strongest available in American law. These are not paper walls. They are walls with constitutional foundations. But the coalition is not asking the court to tear down those walls in the first instance. It's asking the court to require that the compliance framework demonstrate awareness of what's on the other side of them. And that is a narrower ask that may have a better chance of surviving the procedural objections than a direct assault on executive privilege would. The distinction between what the coalition is asking for and what the administration is arguing against may be the most important thing to watch at Wednesday's conference. Because if the court reads the motion the way the coalition has framed it, as a compliance standard question rather than a privilege-piercing question, the administration's primary legal defense doesn't connect to the actual issue being raised. Let me bring this together, because the shape of what happened last night deserves clarity. 14 months ago, a pattern emerged that looked wrong to people watching it carefully. 11 weeks ago, that observation became a formal legal challenge. 7 weeks ago, a judge began reading what the people inside those rooms had actually written to each other. 4 weeks ago, 30 sealed pages arrived in the record. 2 weeks ago, a 4-hour emergency hearing happened with no public entry. Last Friday, the ruling landed with the word predetermined written about the United States Department of Justice. And last night at 11:47 p.m., attorneys who had been working through the night filed 37 pages arguing that everything the court found was the output of a system, and the system has an origin point that lives outside the building the court's injunction currently covers. The comfortable version of this story, the one where Bondi is the protagonist, the DOJ is the bounded arena, and the fallout has a ceiling at the department level, that version stopped being available at 11:47 last night. The ceiling was tested by the logic of a legal argument that is now formally before a judge who reads everything placed before him and writes about what it shows with a precision that does not leave room for comfortable ambiguity. The names in the filing point toward a specific category of person in a specific place in the executive hierarchy. The court knows how to follow that logic. It has already demonstrated that. The question of where the predetermined orientation originated is now formally posed to a proceeding with 18 months of supervisory jurisdiction, a compliance deadline bearing down, and a judge whose track record in this case is to engage the substance of what he's given rather than look for reasons not to. Something changed at 11:47 last night. The filing exists. The court will read it. The court will write about what it shows. And what it shows is that the story that started with Bondi now has a question mark over something significantly larger. I'm going to stay in these documents because the story moves when the filings move, not when the coverage catches up. And right now, the filings are moving faster than anything the administration's compliance team or the morning news cycle was built to handle. The clock is running. The inquiry is expanding. And the judge has 18 months left on the clock, he said himself. Stay close to this one.